My parents are taking me to court to try to get full custody of my kids. This is really bad news because if they win, that means that all the child support money that my baby daddy pays me is going to go to my parents instead of me.
I think child support should be put on a card that you get to track what it's being spent on.
Fellas, I know y'all gonna call me a pick-me, but I'm not a pick-me. So what are all things that support the kid, right? You have rent, you have lights, you have water, you have the car note, you have groceries. And then if the child goes on a field trip or something and it costs $20, that's coming from her as well. So all of these expenses are things that she's taking care of on the regular, with or without child support. Boom, then your child support hits, right? And it's $200. But so was the light bill. The light bill was also $200, but she already had paid it. So when she goes and gets her nails done or her hair done or have a spa day, right, from taking care of the baby, what's the beef?
I am scared. I'm honestly scared. Up to this point, my soon-to-be ex-husband has allowed me access to some finances. However, he has dwindled it to the point that he says he can no longer support two households. Of course, one of those households is the household that he has created moving to New York City. Yesterday afternoon, I received a phone call from my attorney and we went over what my soon-to-be ex-husband is claiming.
Welcome back to Law Unpacked. I'm attorney Sean, and I'm your host. We're diving into a topic that affects so many people, family law in Florida. Whether it's divorce, child custody, or prenuptial agreements, there's a lot of confusion out there. And who better to break it all down for us than our in-house family law attorney, Joshua Tyson. Josh, welcome to the show.
Thanks, Sean.
Let's start with the big one, divorce. Florida is a no-fault divorce state, but a lot of people still have misconceptions. What's the biggest myth you hear from our clients?
Usually they have to do with gender bias. Many people think that only the mothers will get favoritism when it comes to custody, or that they will be the ones who can get alimony in the event of a divorce. However, simply not true. Florida has no gender biases in making their determinations. Another is property that you own prior to a marriage. Many people think that I had it beforehand. It's going to be mine. I don't owe them any portion of it. Once you become married, from then on out, any active or passive appreciation of that property will be split between the parties.
So just so I heard you right, so let's say I own a house prior to getting married. Now, once I'm married, the appreciation of the value of that house is now marital?
That's correct. It's coming up a lot recently with the surge in the market. So something that we've been going over with quite a few people.
Now, finances can get messy in a divorce. How does Florida handle splitting up assets if is it 50-50?
Typically, it is 50-50. Florida does what's called equitable distribution. So if you can show a reason why it shouldn't be 50-50, the courts will hear your argument and make a determination that they feel is fair. Where we normally see this come into play is when there's been what the courts refer to as a dissipation of assets, or what you might consider waste of assets. And this, you see this a lot in when there's an extramarital affair. Let's say you buy a $50,000 piece of jewelry for your paramour. That $50,000 is going to be considered a dissipation, and the other spouse will be entitled to an offset.
So, and for those that may not know, what is a paramour?
That would be the other person. If you were having an extramarital affair, that would be the new person that you're seeing.
So let's talk about kids. What's the process for deciding custody in Florida? And is there any truth to that the court favors mothers over fathers?
No gender bias. The mothers are not favored. Florida in 2023 put in what they call rebuttable presumption of 50-50 being in the children's best interest. So unless there are some outstanding issues that would cause that to not be appropriate, you're going to have equal time sharing with the kids.
Everybody says, I don't want to have to pay child support. Or I want my ex to pay, millions of dollars in child support. How does Florida calculate child support? And what happens if someone refuses to pay?
So Florida uses what we call the income shares model. It takes the total income of the two parties and the number of kids, And that gives us a total amount of support that we feel will be necessary for the children each month. From there, you'll take the amount of overnights that each party has and each party's portion of the total income, and that's how we get our number. So if the total support needed for a month is $1,000 and the two of you have equal time sharing and you make 60% of the total income, you would be responsible for that additional 20% being paid to the other side. So $200 a month would be that amount.
So now I want to switch gears to planning. What's your take on prenups?
So definitely always a good idea. Let's get everything worked out while we're cordial and while we're all still in those lovey-dovey feelings. No matter if you have $1 million in the bank or $500 in the bank, um, having to split your assets is going to have a big impact on your life. I would say sometimes more so when there's less to split.
But oftentimes you hear, what, you don't trust me? One partner says to the other. How do you overcome that when drafting these?
Oh, if someone has those suggestions, what we generally tell them is, well, understandable. No one wants to go into this thinking it's going to end. Ideally, you're going to be together for the rest of your life. But going into this, you should trust your partner that you will be together and you can sign this document with no concerns that any of the terms in it will ever be relevant.
You know, a lot of folks are saying, oh, I don't need a prenup. I don't have anything, or they're just for the rich. Does it make sense for everyday couples?
It absolutely does. If you're an everyday couple, both of you work 9 to 5, you are going to want to have this done in the easiest manner you can. If both of you start fighting when a divorce comes about and there's no prenup in place, you're going to go through a lot in litigation fees trying to get this completed. And you're going to have a lot of uncertainty as to your financial future. So, definitely important for um, all parties, regardless of their income status, to have a prenup in place.
What are some of the clauses or the language in prenups you would recommend?
Always want to discuss alimony. That's generally some people's biggest concerns when they're looking to have a prenup done. We also want to clearly define what are marital and what are non-marital assets, and if there are non-marital assets, what we're going to do with the any appreciation that occurs during the marriage. Also, if the two of you buy a home during the marriage, we're going to want to clearly define what portion of the equity each of you will receive, if you would need to sell it, if one of you gets to stay in the home afterwards. Also, if there's a 529 college plan for your children, if that's going to be split up or if that's going to continue, who's going to be responsible for it. Also, retirement plans. We always like to get those taken care of so you know for your future if you're going to be separating what you're looking at long term.
So we've talked prenups. Now let's talk postnups. What exactly is a postnup?
Postnups and prenups are essentially the same document when you're looking at them drafting wise, but a postnup occurs after the marriage. This can oftentimes be beneficial if you have a large amount of assets that have been created during the marriage. Say you both came into some money, you have now bought a good bit of stocks, or you didn't have retirement plans or long term insurance prior to coming in. You can now go through, list those, have it clearly defined what's going to happen to them.
At what point during a relationship should you ask for the postnup? Is it when things are on the rocks or when things are going good? I mean, this is kind of an unusual document, right? Because you've already been married.
They are rare, much more rare than prenups. Recommended that you do them while the both of you are still on good terms. However, generally we do see them when things have started to go south. That's when they're more commonly asked for by our clients.
If you do a postnup, does that just you no longer have to get divorced through the courts, or what happens after you do a postnup?
So the postnup has no legal bearing on your marriage. It's a contract, and we have language in it that these terms do not come into play until one party has filed for a dissolution of marriage. So that would be a triggering event.
Let's talk prenups and postnups for a moment. When looking for an attorney to help you draft one of these, what should you be asking the attorney to ensure they have the experience to be able to handle this?
You'll really just want to know that they've they've done them before. If they have perhaps a sample that you can look at, you'll want to ask them what questions you haven't come up with for them. And that should give you a good indicator of what their knowledge is of the area in general. Because there are many things that people don't think about, such as active and passive appreciation on property and how that would be divided, how equity would be divided if property is sold. Also, clauses that you can have included that wouldn't ordinarily come up in a divorce, such as infidelity clauses and what would happen in those scenarios.
So let's talk about children for a minute. Within the prenup and the postnup, is there any language in there dealing with children and child support and child custody type in most situations?
In most situations, we'll put something in place. However, those are generally not enforceable by the court. The courts are always going to determine child custody and time sharing for what's in the best interest of the child as determined by the court. Now, you can, of course, agree, and assuming there are no outlying factors such as domestic violence or things of that nature, the courts are going to go along with what you have in for time sharing. Child support, again, that is a right of the child, not something that can be waived, although some parties do try to waive it in a prenup or postnup. But the courts will only allow you to deviate up to 5% from the Florida guidelines.
And you mentioned when you were speaking about the best interest of the child. Is that a Florida legal term? And can you help define that for us?
Sure, that it is a Florida legal term. We have what we call best interest of the child factors, and the courts are going to look at things like domestic violence, geographic viability, which is how far away from one another the parents live, and how that would impact the child's life, the physical and moral fitness of the each parent, maintaining stability, the need for use of third parties, keeping the children in a routine. Also, your willingness to foster a relationship with the other parent.
Josh, is there anything that I didn't ask that a client or a potential client or someone that's going through family law issues should look for or should think about when deciding to do a prenup or a postnup?
Definitely, you're going to want to talk to your partner beforehand. Also, this is something you're going to want to have put in place as far as a prenup well in advance of a potential wedding. One way to have your prenup tossed out is if there is fraud, coercion, duress, or undue influence. And we would consider duress if you give them the document the day before, everyone's already in town, and you say, hey, sign this or the wedding's off. They may sign it, and the court later say they signed this under duress, and the whole thing be unenforceable.
How long does it typically take to draft one of these documents, or how long would you want a client to come in to see you?
Generally, as early as possible. The actual drafting of the document doesn't take very long. We can have it done in generally a couple of days. What takes time is putting together the list of assets and having the parties agree on what the terms are going to be. Uh, you'll want to make sure that full financial disclosures are made prior to the document being finalized. And we generally advise people to attach a financial affidavit to their prenuptial agreement, one filled out by each party. That way, there can be no mistake about what was disclosed and what wasn't if a dissolution of marriage does occur in the future.
So you've been practicing family law over 10 years now, and you've seen pretty much it all. What are some of the biggest challenges that our clients face when going through a family law issue?
One of the biggest challenges we have with people are getting over the mindset of trying to win over the other side. What we try to encourage people to do is win against the other possibilities that you have. For instance, we have cases where offers are made and it doesn't include something that you are somewhat stuck on, but they're giving up other things that will make it financially beneficial. So If someone's willing to waive back child support, waive their rights to your life insurance, but they want the credit for taxes, um, you'll want to make sure to weigh those things out and not just be so focused on, no, I want this so I can say I'm the majority parent or things of that nature. You keep in mind what's best for you and what's going to be best for the child, and not winning against the other side.
Well, Josh, that was incredibly insightful. If someone in Florida is dealing with a family law issue, what's the first step they should take?
Definitely speak to a local attorney. You'll want to know your rights and responsibilities and what kind of time deadlines you might be on if the other side has already filed. Because there are things that go into place once filing occurs, or things that won't go into place until filing occurs. So if you are the what we refer to as custodial parent, most known as the majority parent, and you're not receiving child support, child support can go back to 2 years from the date of filing. So you want to make sure to get that filing in quickly. If you are the non-custodial parent or non-majority parent, the other party can relocate until you have filed with the court. So filing and having them served locks them into not being able to leave the state of Florida without the court's permission or without your permission.
Well, Joshua, thank you for sharing your expertise. If there's anything, is there anything else that you would like to tell our listeners and our viewers?
Not at this time. I think that covered it, Sean. Thanks.
And to our listeners and viewers, if you found this helpful, don't forget to like, subscribe, and drop any questions in the comments. See you next time on Law Unpacked.